All right, the court is calling 2025 CR 005931 State versus Ricardo Javier Reyes. Can I have parties announce for the record?
Rick Vanier for the state of Texas.
And are you Ricardo Javier Reyes?
Yes, Your Honor.
All right, you entered a plea on August 12th, 2025. There was a PSI that was completed. Any objections to the PSI, state or defense?
None from the state.
No, Judge.
And so that the record can be clear, the PSI report, the pre-sentence investigation.
I mean, we can.
According to your plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. The state opposes your application for deferred adjudication. They're recommending community supervision. They're taking some cases in consideration. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Counsel, do you wish to speak to deferred adjudication?
I do, Judge. I understand that this is probably going to be big ask for the court to allow him to be placed back on deferred. He did have a deferred. It was for a felony. He did complete it successfully. Tells me that he can do it. But understanding having that kind of a history probably does not make the court feel very comfortable. But we would still request deferred, Judge. He had, without delving into the relationship he had with Miss Walls, it was dysfunctional and toxic. It was a two-way street. I know she has very
Okay, so
strong
here's the thing.
Yes.
Don't shake your head up and down, because let me just tell you, I've read the police report. Whether a relationship is toxic or not, you chose to be in that relationship. There are several cases that are pending where you're accused of assaulting her. And you're here for an assault family household with a previous conviction, which means you've done it before because it's a previous conviction. I will tell you, counsel, I'm leaning towards giving him deferred, and let me just tell everybody why. Because if I were to follow your plea bargain agreement, if he were just on regular probation or community supervision, if he were to not complete it successfully, the most you could get would be the minimum. But with deferred adjudication, the full range of punishment is open to the court. So the question is, do you want the full range of punishment? You know yourself better than I do, better than your attorney probably does. So if you want deferred adjudication, I will give you deferred adjudication, but you're going to be on deferred adjudication for 8 years.
Thank you, Your Honor.
And do not come to me for early termination.
State would just oppose that for the record, if I may, Your Honor. Given the number of cases he has against this particular victim, state doesn't feel like he would be an appropriate candidate for deferred, and that's why we're seeking that defendant be put on probation with a conviction.
I don't think he's an appropriate candidate for deferred either. However, the plea bargain you all have reached, if he were not to successfully complete probation, he's looking at a minimum of 2 years, which is the minimum sentence. If the court were to place him on deferred adjudication, he would not successfully complete it. He's looking at 10 years in the prison. So, Mr. Itoshi?
I mean, it appears as if Mr. Reyes still wants the deferred, understanding that the term is 8 years, that the court will not entertain an early termination. As far as trying to delve back into the relationship, that he'll never communicate with her again. We've talked about this. So she is, in all practical purpose, dead to him. So he's not going to go back and visit with her. And then the rest of it's up to him. I've told him that this court can be very, very strict when it comes to things like this. He now clearly understands that. I've told him he has to walk the line regardless of what decision the court makes, because it will not end well for him if he does not. He's aware of it.
And state, I understand your position with wanting the felony conviction,
Yes.
but there still will be an affirmative finding of family violence, so it will not go away. And this can be used for enhancement purposes. Do you understand?
Yes, Your Honor.
All right, so again, you know yourself better than I do, better than the state does. If you want, I will follow your plea bargain agreement where your underlying sentence will be 2 years. What that means is if you were unsuccessful, the most that the court will be able to sentence you to is 2 years. Or if you want, I will give you the deferred adjudication for 8 years. And if you're unsuccessful, the court could potentially sentence you up to 10 years in the prison. Which do you prefer?
I prefer deferred.
All right. Ms. Abrams, are you ready? Court is going to sentence you to 8 years deferred adjudication.
Thank you, Your Honor.
You're welcome. There's to be regular reporting by Zoom or in person. Regular random UAs. And let me see. I'm going to follow the recommendation of TAP, intensive outpatient treatment. Are you in any type of,
I'm in outpatient right now.
all right,
Yes, ma'am.
With-
With Camino Real. It's in Jordanton, Texas. I've been doing that already for almost 2 months.
all right, he's to continue,
That's exactly what probation recommended him to do, yes.
all right, so he's going to continue with treatment with, you say Camino Real,
Camino Real, yes, ma'am.
and spell the last, is it ROY?
REAL.
I'm sorry?
REAL.
Ah,
It's on the first page.
all right, thank you.
Want to look at the.
Yes,
sign.
please. Thank you. All right, so you're to continue intensive outpatient treatment with Camino Real. As a part of that treatment, do they have you do sober support meetings?
Yes, and also every week I have to meet with my psychiatrist and also a therapist, and it's been going great. I mean, it's very helpful.
All right. So he's to continue with that treatment. You're going to have to sign a release so that probation can make sure that you're keeping up with everything you need to keep up with there. Do you have any children?
Yes, I have a daughter.
What is her age?
She's 10.
All right, there's going to be 100 hours of community service restitution. I'm going to require parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. There's an affirmative finding of family violence. There's to be the BIP course. There's to be no contact with Kimberly Walls. Take in consideration 2025 CR 005929 and 2025 CR 005927. There's a $1,500 fine. That will be probated. And I'm sorry, where did you say you were, what location for the treatment?
Camino Real.
No, I mean, what county?
Jordan,
Jordanton. Yes.
Okay, and how far is Jardington from here?
about 30
I think That's
minutes.
Wilson County, right?
Jordanton is Atascosa?
Atascos.
It's at Wisconsin. Yes.
Right, so, probation, does there need to be a transfer or no?
You don't know that.
I do.
Oh.
If it would be okay, I would. I mean, that's where I
I
live.
was not aware of that.
No, Judge, however, I mean, he can report here, however, the bill visits.
All right. So is he says he wants to transfer there. All right, and you say that's Atascosa?
Yes, ma'am.
All right, so there'll be a transfer to Atascosa County. Probation, is there anything else? Thank you. There's to be proof of employment within 45 days. No employment as a home healthcare provider or with minors. Anything else, probation?
Did you want me to add a bill visit one time a month?
Yes, let's see. And then if they are unable to do it. So field visits one time per month. For 6 months. Is there anything else you need from the court?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. Obviously, you cannot drink alcohol, not even a drop. Number two, when I say there's to be no contact, it's exactly what it means. Do not call her. Do not send her apology letters. I know as a part of the 12-step program, you have to apologize for things that you've done. If you want to do an apology, you send it to probation. You do not send it to her. Do you understand?
Yes, sir.
If you have any contact with her, that will be a violation of your probation. Do you understand?
Yes, sir.
Is there anything that you do not understand about the court's instructions today?
No, Your Honor.
All right, well, stay on track with your sobriety. Thank you for dressing appropriately for court. Good luck to you.
Your Honor, victim is present. She'd like to have victim impact statement.
All right, sure. Michael Balderas. So where are we on discovery on this case?
To my understanding, Judge, I have all the records that we have ordered.
There's no CPS record?
There are CPS records. We do have them available, and I just would like to get them signed before releasing.
And Judge, the discovery is not on the discovery system.
Mhm.
I spoke to the prosecutor. He's gonna have me bring in a flash drive. I'll bring it in tomorrow.
All right. And State, were you able to tender an offer today or no?
Yes, Your Honor.
All right, Ms. Ferguson. On Balderas, I need a plea deadline date in December, please. All right, December 1st, that's your plea deadline date. If you have not reached an agreement with the state, what will happen is you will have a jury trial set. Your plea deadline date will have expired and the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. What I can tell you is, based upon the jurors that will be available in the month of December, your case will be tried most likely in the new year. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
One issue, just since we haven't had access to the discovery yet, if there's any issue. I'm free to
Then
follow.
you need to come in before December 1st and let the court know.
I'm gonna let the court know.
All right, thank you.
Thank you.
And if you'll have a seat, once you sign the reset form, you're excused.
Thank you.
Thank
Thank
you. All right. Yeah, we got this case transferred. So who is the prosecutor on Jasmine Brasinho? It's, I think it's criminal trial division.
Yes, Your Honor. I don't think any of us have really looked at the case yet, so it could be any one of us. It just got transferred to our court, so we're not up to speed, I guess, on all of the circumstances surrounding the case.
All right. So, Ms. Ferguson, I need a 30-day reset for discovery. All right, your discovery date will be November 13th. Once you sign the reset form, you are excused, and make sure you're on time next time, all right? Thank you. Just have a seat. Your attorney will bring the reset form to you.
Thank you, Judge.
Thank you. The parties on June Bright. Have you had a chance to review the PSI report?
Yes, ma'am.
All right, do you have any objections to the court reviewing it?
No, ma'am.
Just give me 2 seconds. I want to see what the TAP evaluation says. Bashan? Bashan, do you know the TAP evaluation on June Bright? No, it's the TAP isn't on here. I have everything except the TAP. Thank you. Welcome. And you've had a chance to review the TAP?
Yes, ma'am. And I reviewed it with Ms. Bright.
Thank you. All right, the court is calling 2025 CR 002-831, State versus June Bright. Could I have parties announced for the record?
Megan Crowley for the state.
Ashley Morgan on behalf of Ms. Bright.
And are you June Bright?
Yes, ma'am.
All right, I'm gonna need you to speak up so the court reporter can hear.
Yes, ma'am.
So you entered a plea in this case. And according to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. The state is recommending community supervision. Have both parties had a chance to review the PSI report and the TAP evaluation?
Yes, ma'am.
Yes, Your Honor,
Okay.
sorry.
No problem. Any objections?
No.
There's no objection from the
Okay.
minutes.
All right. Is there anything, state you wish to put on the record?
No, Your Honor, I believe that we had recommended community supervision in this case, and I believe it was just reset for her to receive her evaluation, so I don't have anything additional to add at this
All
time.
right, state you may be excused. So Ms. Bright, how are you maintaining your sobriety?
I work
Mhm.
and I crafting, I do arts and crafts. I make different type of jars, different decorations,
Okay.
tip jars for like businesses and stuff.
Mhm. I've
And
never been good at crafting. I try, but
it's relaxing. It's
Oh,
very
awesome.
relaxing. So I've been doing that for about a year. I've let some people see them and they really like them. So I'm gonna launch that business probably in the beginning of January. Where, make my own custom tip jars and take them around and vend in different events.
oh, that is
at the
awesome.
vendor. Yes, ma'am.
The holidays are coming up. You may want to try to get into the holiday.
Yes, ma'am.
holiday scene.
I've made some with Halloween decorations on them already. I made some with Christmas decorations. So every season I have a tip jar for that.
You should have brought one so I could see it,
Yes, ma'am.
but I'm sure they're great. All right. Is there anything you wish to say?
Yep, Judge, we're just asking that you follow the agreement, especially the PSI. I think they did an accurate evaluation of my experience with Miss Wright.
All right. Are you doing any type of, oh, I'm sorry, go ahead.
I was just gonna talk to you about the jail time, the 10 days condition.
Oh, okay. Well, before we get to that, so, are you doing any sober support meetings or anything of that nature?
I haven't started any support group meetings, but I'm looking forward to and I want to meet and talk with some other people and then as well as do therapy in the VA through the VA and the veterans. So
Okay.
I'm gonna sign up for that program.
All right, so I tell you what I'm going to do. I had no idea she was a veteran. All right, everyone, please whisper. Probation can't hear. There's something wrong with the mics. Thank you. All right, so what I'm going to do is I will sentence her and then we can see if Veterans Treatment Court will take her. State, if Veterans Treatment Court will take her, would y'all have any objections to doing a motion for new trial? For placement in Veterans Treatment Court, if they will accept her. So health court.
Okay,
You're
yeah,
right.
because she's already on community supervision, but because this offense is not eligible for deferred, so.
Yes. All right. So then I'll do a referral for you for Veterans Treatment Court. So the conditions I'm going to give you, if you're accepted into Veterans Treatment Court, they will give you different conditions because you will no longer be under the umbrella of probation here. Do you understand? All right. So that may be a good placement for her. All right. Thank you. All right. So this is what the court is going to do. The court is going to sentence you, as previously stated, the court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 3 years. There's a $2,000 fine that will be probated. Ignition interlock. You all didn't say if you wanted it half term.
Half term, yes, ma'am, I think that's for the agreement.
All right. It's not listed.
Okay.
Yeah. So I tell you what, probation, I'm gonna do ignition interlock for full term. However, at the half term, you can come if she's doing well. More likely than not, I will grant the removal.
Okay.
So ignition interlock full term. 2-year license suspension. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home healthcare provider or with minors. Field visits 1 time per month for 6 months. 200 hours of community service restitution based upon your service. What I will do, I'm going to order 60 sober support meetings in 60 days. For every sober support meeting you do, an hour of community service will be waived. There's 10 days in the Bexar County Jail as a condition of probation. You can either do the 10 days in jail, but because there are health issues at the jail, overcrowding at the jail, I can either give you GPS, ask that the fees be waived. You'll do it for 10 days, and that will be full GPS. Or if she has employment, then it will be 30 days and it'll be partial for employment. So if she wants it on just for 10 days, that will be full GPS.
She does work, Judge, so she would want it for the 30 days with fees waived if possible.
All right, 30 days GPS in lieu of the 10 days in the Bexar County Jail. Waive fees. It will be partial GPS for employment. DWI education course, victim impact panel live.
And do you want the education or the intervention?
Usually
It's
usually
intervention.
probation will tell me if they want education or intervention. So, Ms. Abrams, it can be DWI education or either the intervention course, and I'll let probation decide which is more appropriate because. All right. Because sometimes the PSI report doesn't give me insight, all right? All right, is there anything else, probation?
No, sir.
Is there anything else you need from the court to be successful?
No.
All right, and I'm sorry, probation, we'll do a referral to Veterans Treatment Court. Thank you. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When people drink and drive, it's not good, right? Especially when they're intoxicated. This is what I discovered. Usually, if there is an accident, the person who is intoxicated, they just walk away just fine.
Yes,
It's their passengers and other people who are just trying to get from point A to point B.
yes.
If people want to drink, it's like make plans, have a designated driver. And designated drivers love that. I loved it because I would always get free meals. All right. So you're gonna have to make sure that you stay on top of everything, all right?
Yes, ma'am. And,
Okay.
and for,
Mhm.
for me, I just want to interject. One of the mistakes I made is I fell in love with a narcissist instead of staying in love with myself.
Mhm.
And so from the time of the sentencing up until now, I've done a lot of self-reflecting and self-discovery and rediscovering myself and falling back in love with myself.
Oh, I'm so proud of you for doing it. A lot of people don't do that. They go from relationship to relationship, but you gotta figure out who you are.
Yes,
And
ma'am.
now that you know who you are, guess what? If you get into another relationship, you gotta already know what your no-goes are,
Yes, ma'am.
and then don't cross the line.
Yes.
All right, good luck to you, okay?
Thank you.
You're welcome.
Judge, I don't know if you meant to hand that to me.
Oh.
You've already given me.
Thank you.
You're welcome. That's it.
Juan Rios? Hi, you're on this side, your client's in the middle. Oh, what are we here for?
Good morning.
Good morning.
Your Honor,
You were
first-
late.
That's why I was bringing him up.
Yeah. All right, well, let me just see here, just 1 second. You've never been late before, so what happened?
I think 35 is construction. The line to get into the court is in the street, right in the corner
Mhm.
of the street. Parking lot is packed. It's pretty hard to get space, to get the space for park.
Oh, yeah.
And I mean, it takes me, I got here at 9 o'clock 10 till 9, but inside of the main entrance, it was the problem that to me
Oh, no, I understand. I,
get here early.
one time I left at 7 a.m. and there was construction from one end to the other and I barely made it here for 9. So, yeah, I
But
understand about the
I'm
construction.
sorry.
No, no, you've
No.
never been late before and you always dress appropriately for
Yes.
court. I appreciate that.
Thank you.
All right,
But we are also setting the trial.
yes.
We have a motion for continuance on file.
All right,
I don't know if you want to address that now or later.
oh, do you have the motion for continuance? All right.
Give you a written copy, the state received it.
I've had a chance to review it. I don't have a copy with.
All right, so if you want to, you can make some copies and back and then confer with the state.
We've conferred about it. There are just a couple of matters that we need to make the court abreast.
Okay, all right, so if you'll make copies in the back, all right, just have a seat.
Thank you.
You're welcome. So what is happening with Mr. Dixon?
Judge, I talked to Dr. Murphy's office this morning.
Mhm.
She did interview Mr. Dixon last week, and she is writing her report. She's going to have a draft done by the end of the week. I'm requesting a 2 weeks of reset for me to get that report. Then I can talk with Megan about a realistic plea agreement in this case. We have 3 cases pending. I have continuances filed on all 3 for waiting on Dr. Murphy's report.
Judge, I believe this is the second continuance for this reason. However, I'm not gonna necessarily object to the solution for continuance, but the state is ready for trial today.
All right. So your disposition date, and you said she'll have it ready for by the end of the week?
She told me a draft by the end of the week. I really don't know what that means.
Okay. Ms. Ferguson? On this case, recall this for October 28th, and that's your jury trial date. And Deputy Laura, Mr. Dixon needs to be brought over dressed for trial on October 28th. All right, so here's the thing, Mr. Dixon. If you don't want to dress for trial, that's your prerogative. What will end up happening is you will be tried in that orange jumpsuit. Do you understand?
Yes, ma'am.
All right, October 28th.
Judge, did you want to deal with these motions or just,
What are your motions?
it's just their continuances on all 3 cases?
All right, well, we can take that up on October 28th. Thank
Good
you.
to me, Judge. Thank you.
You're welcome.
I appreciate the board's time.
Sure. All right. Christina Lozano. And before we go on the record, so in the PSI report, Thomas, they're requesting $1,700. They're saying the iPhone, they're saying she took $1,000 through Apple Pay. Broke the iPhone. And that's 1,100. So that's 2,100. And then they're saying that she paid $600. All right, I don't know where they're getting the 1,700 from. Does anybody know?
My reading of it, Judge, was that the transfer of money was 1,000 and the phone was about 700.
Oh, just 1 second. I thought it said she had paid 600, but it says she paid 400 in restitution. So doesn't that put us at $1,600 instead of 1,700?
Oh, I see, 2,100 less $400. Okay, so it was 2,100, but she paid 400 through the detective. That must be where the outstanding 17 comes from, Judge.
Okay, so it's only. All right, so let me just do the math. So she's saying that there was $1,000 stolen from Apple Pay. Then the phone was valued, oh, I thought, okay, the phone was valued at $1,100. So you're right, that puts us at 2,100. And then, okay, and then she only paid $400. So what do they mean? She failed to pay the remaining 600? Is that the remaining 600 towards the $1,000 or something else?
Unclear. If I were to guess, Judge, it would be she had agreed to pay the 1,000 back that she sent through Apple Pay.
Mm-hmm.
And so that was the 600 of the 1,000 left, and she paid 400.
So she owes 600 from the 1,000. And then, and then it's $1,100 for the cell phone. So that's $1,700 they're saying is owed. And then I think then from Randolph Brooks, it's $36.74. So does she have the money? It's $1,700.36. $1,736.74.
So Judge, my understanding was that the detective, who was really reaching out on the behalf of, it was Nicholas and Lauren Thomas, excuse me, asked for $1,000. And that's what he had communicated, on which she began making payments to. But discussing the matter with her, I mean, she would most likely have to get on some sort of a payment plan to get this restitution back.
Do you have the money?
I mean, I can get it by the end of the day. I do have a degree since.
So you can get that by the end of the day? All right, so that $36.74, that goes to Randolph Brooks Federal Credit Union. And then you have the $1,700 to go to the Thomases. And you say you'll have that?
I can get it by the end.
I'm sorry?
I can get it by the end of the day, yes.
When you say end of the day, what do you mean?
Like by 5 o'clock.
All right, then what we'll do, we're going to recall this back tomorrow and you need to come with a cashier's check.
And Judge, I leave after lunch for a conference for the rest of the week.
All right, are you able to Zoom? No?
If this court needs me, I will make myself available.
I'm sure somebody, look, somebody back there said they will stand in. So if you will give them the names, and she's gonna bring the cashier's check for that for tomorrow, because I don't like for people, I've discovered, placing people on probation, it never gets paid. So bring that cashier's check with you tomorrow for both of those parties, and then we'll do sentencing on that day.
Yes, ma'am.
All right, Ms. Ferguson, she needs a reset for tomorrow. And they will, counsel, if you make sure she has the correct names to make the cashier's check or money orders out to.
I will, Your Honor. I have their names.
And
All right,
and
thank you.
Judge, we did have Miss Finland here. If we do this by Zoom, is she able to Zoom in also?
Any objections?
I had no objections to any victim impact statements being done through Zoom. I'd just be here in person, Judge. I have cases here tomorrow, so that's
Right.
I'll handle my end of it.
All right. Arnold Pena. Hello. I don't have the indictment with me. What is RKLS?
RKLS. Reckless.
Thank you. All right, so what is happening with this case?
Judge, I believe, Mr. Campbell conferred with Miss Alban. And, she informed him that she needs to reach out to the complaining witness in the case, and I believe that he is requesting some discovery on a hard drive at this time.
Mhm.
That's correct, Judge.
All right, thank you. All right, Ms. Ferguson, I need a 30-day reset for discovery. All right, we'll bring you back on November 17th. Do you have any questions?
No,
All right, thank you.
thank you.
Fidencio Gonzalez. All right, what is happening with this case and why is it? It has a 2024 indictment date.
Sorry,
What's happening with this case?
the discovery is complete, Judge. We've reviewed it. They made an offer. he's rejecting that offer at this time.
All right, so sir, there's no at this time. If you are not reaching an agreement, because today is your plea deadline date, the court will not consider any further plea bargaining agreements in this case without good cause. Do you understand? All right, we'll see you back at 1:30.
Today, Judge,
Yes,
or
jury trial.
you're not gonna be ready at 1:30 today. My understanding was that we'd have a trial setting after the plea deadline.
Well, his plea deadline date was actually October 2nd. Then we kept bringing it back.
That was discovery issues, that we didn't get all the discovery until October 2nd.
Okay.
Is when we got it.
All right, I'll see y'all back at 1:30. Isaiah Guerrero. All right, so where are we on this case?
We are applying for PTD today, Judge.
All right, Ms. Ferguson, I need a date for PTD. All right, we'll be back on November 17th. Here's the thing. If I were to drug test you today, how would it be? Right? So if you're doing PTD, you are going to have to take it seriously and you're going to have to get clean and sober, because otherwise what's going to end up happening, one, maybe your PTD is going to be rejected. Two, maybe you'll get caught before you use drugs. And if you do, that's another possession charge for you and you'll end up going to jail. There are plenty of places that can help you. Today, when you leave this courthouse, you need to go and get in a sober support meeting. Do you understand? All right, good luck to you. Troy Moore.
Morning, Judge.
Good morning. Hi.
So this was reset last time, so Mr. Moore could have an eval, and it didn't happen. There've been some mix-ups, but we've talked this morning.
Okay.
Either way, it's gonna be a plea, whether he's accepted or not, so I don't want you to worry about that, but we just want to make sure he gets evaluated. If he is qualified for Veterans Court, we'd like him to at least have the opportunity.
Well, here's the thing. If y'all do a plea, I'll ask for a referral to Veterans Treatment Court.
The second thing is he has a case in Comal, and I'm trying to get his attorney to talk to me on that one and see, because I don't want that to screw him up. If he gets veterans and then they end up taking him over there, if we can get something worked out. So I just need a little bit of time to do that. Well, state didn't have any objection.
I just need a referral, Judge. If you'd like for us to evaluate him,
How long will that take?
we're booked, so as you know, with the new identification system in the jail, we got about 240 names. We're booked up to about the first or second week of November on assessments. I know. I just got told about the situation, or I would have been able to do something.
All right, so this is what I'm gonna do. We're gonna reset this before, we'll do like November 13th. You should have hopefully had contact with the other attorney. And then that's gonna be your plea deadline date. And I'll do a referral to Veterans Treatment Court. Norma, recall this for November 13th. And that's the plea deadline date. And then a referral to Veterans Treatment Court.
And Judge, we'll do whatever we can, to make sure we have an answer for you on that date.
You're so awesome. I appreciate it.
Thank you, Judge.
And then Ms. Abrams tell you about Ms. Bright.
We're gonna handle that one too, Judge.
Okay, all right, thanks.
You're welcome.
All right, thank you.
Thank you, Judge.
Thank you.
All right.
Sebastian Moreno.
Bit of a change on that, Judge, actually just released it. We're gonna go ahead and get this knocked out.
All right, thank you. Oh, yes, then we'll,
Yeah.
once you're done, bring it up.
Oh, no, I mean, it's just changing from that. I already confirmed with the state. It's resetting. We're gonna ask for a reset for next week. He's already set in his misdemeanor courts on
All right,
Thursday.
perfect, Mr. Moreno. All right, so what is happening?
He said in his misdemeanor court in County Court 1 on Thursday, he's gonna knock out that plea. That plea must be done before we do anything on our felony. That was the deal. Forgive me, Judge, I cannot remember if they were gonna agree to defer this one or plea on those or dismiss as a part of that plea. I do not remember off the top of my head, but
So they're doing that on Thursday?
yeah, on Thursday, the misdemeanor will knock those out. Yes, Judge.
All right, Ms. Ferguson. If you can recall this for the 20th. All right, once you sign the reset form, you are excused.
Thank you, Judge.
Thank you. And Mr. Moreno, you need to make sure you're on time next time. Thank you.
I believe he went to pick. Judge, my system didn't tell him the correct courtroom. That's actually on me. My system just told him go there.
Okay, all right, thank you. Jordan Summers.
Yes, ma'am.
Hello.
Hello.
All right, so there are some issues with you. And are you aware of those issues? So this is me having a conversation with you. Nobody's filed a motion to revoke yet. But depending on your actions, a motion to revoke may be filed.
Yes, ma'am.
So the issues with you are you're not submitting for testing.
Correct.
That's a part of being on probation. You have to test. Why have you not been testing?
I have not had the funds, and like whenever I do have to go test, I haven't had the funds to do so, the time to do it, the exact funds to do that. I have a car payment that I've been paying, so, you know, I haven't been able to get the funds together. at the
All right,
right
when you're
time.
drug tested today, what are the results going to be? And you're going to get drug tested today.
I'm a negative.
All right. So we will, Ms. Abrams. She said, she's available to do a drug test today.
Did speak a little bit about what the other issues listed on the supplemental report is. And basically, she did indicate that she would be negative. She is not opposed to doing felony drug court evaluation. She indicates she is in school currently. She has things to occupy her mind and her time. And she's really just trying at this point.
Okay. All right. So we're going to do a drug test today. You're not going to have to pay for it. And then we will get the result. And based upon that result, that will tell me what should or should not be done. All right. Could you direct her where she needs to go for the drug testing? All right. And then we'll come back here and counsel. It should take maybe 15 minutes. Yes. All right. Thank you. Johnny Lamone.
Present, Your Honor.
All right, the court is calling 2023 CR 4352, State versus Johnny Lamone. Can I have parties announced for the record?
Melissa Alvin for the state.
And Eric DeWalt, I represent Mr. Lamont.
And are you Johnny Armando Lamone Jr.?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Johnny Armando Lamone Jr., who was placed on deferred adjudication in 2023 CR 4352 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on August 1st, 2023 for a period of 2 years and extended for a total of 3 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, we're going to proceed on number 23. On or about the 4th day of December, 2024, in Travis County, Texas, the defendant, Johnny Armando Limon Jr., did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, in that the defendant was using K2 while in the Austin Transitional Center in violation of condition number 23.
How do you plead to that? True or not true?
True.
And then lastly, Your Honor, number 4 on the amended.
Just one moment. I don't have a copy of the amended. Oh, here it is. Just 1 second.
Last night, Your Honor.
Did you review the first amended motion to revoke, motion to enter adjudication of guilt and revoke community supervision with your attorney and understand that as well?
Yes.
All right, state.
In Bexar County, Texas, the defendant, Johnny Armando Limon Jr., did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, and August of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
We'll waive the rest, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 23 and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand that?
Yes.
Knowing that, do you still wish to plead true to 23 and 4?
Yes.
Court will find 23 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is recommending revocation, and I believe the defense is going to ask for something different.
Yes, defense.
And Your Honor, the probation's recommendation was the SATIF relapse. From my client's actions, you could tell that he was in rehab and still using. He is trying. And then he knew he had a warrant out for his arrest. So one, we would ask that the SATIF relapse be considered, or if you're going to sentence him, we would ask for the 180 days.
All right.
And Your Honor, may I respond?
Yes.
Given that his new cases, his new number ones are brand new, at least as far as the new drug cases, we can't indict him on those yet. We don't have the lab results. He can't plead true or not, or he could plead not true, but he can't plead true to those. We can't work those out. And given that those cannot be worked out, SATIF or SafeP is not an option. So we're asking for the revocation.
All right. Anything you wish to say?
I know I messed up.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Johnny Armando Limon Jr.
Yes, and you wanted to say something.
I know I messed up, Judge. I messed up bad, but I'm just asking if I get like a second chance or something. Something I can just try to work with. I got a lot going on out there in the world, and I really don't want to go sit down. But I was asking for a second chance.
All right, so let me explain to you what your problem is. And not really what your problem is, but let me explain to you what your actions were and why you're here.
Yes.
All right. And I'm just not talking about the motion to revoke today. It's you were previously placed on deferred adjudication. The fact that your deferred adjudication was extended suggests that there were violations. And you have had previous violations before. And it was denied. And whenever someone has violations, if I'm going to continue them, I try to address those violations. So previously, you had a motion to revoke, violation of number 2. I denied it, altered and amended your conditions. And then you came back and there was another motion to revoke and I denied it. And I ended up sending you to inpatient treatment. And now you're back here again, and you're back here because you're in the treatment facility and you have illegal substances there. I mean, there's nothing else I can do for you. So the court is going to grant the motion. The court will find you guilty, revoke. The court will sentence you to 2 years in the state jail facility, therapeutic community, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of that, you'll need to speak to an attorney. Do you understand?
Yes.
Here's the thing, we can go off the record. Here's the thing, when you're released from custody, if you can't find a sober support system or a place to stay, if I'm still here, you come back here, I'll pick up the phone and call somebody to place you in a treatment facility. Do you understand?
Yes.
All right, take advantage of the therapeutic community that's there. All I can do is recommend it for you. It'll be in the judgment, but you have to ask for it too. I don't have any jurisdiction over the prison, so I can't force them to place you in the program, but it will be helpful to you if you're able to get in that program. All right, good luck to you.
Thank you, Your Honor.
Thank you. Juan Rios. All right, the court is calling 2023 CR 6483 State versus Juan Rios. Can I have parties announced?
Megan Galloway for the state.
Joseph Holscher for Mr. Rios.
And you are Mr. Rios?
Yes, ma'am.
All right, you're scheduled for jury trial today,
Yes.
and you filed a motion for continuance?
Yes, Your Honor. So in this case, there are 3 different blood tests.
Mhm.
We have an expert, Mr. John Castle. Mr. Castle has, I think he was embarrassed to put it in writing. He has a UTI, and I think it's developed into a kidney infection. So because he gets treated through the VA, apparently there was some delay in him getting the UTI addressed.
Mhm.
He has a set of appointments scheduled to put him on antibiotics. We conferred with the state on dates, but he's unavailable now. And I really do need a blood expert because like I said, there's 3 separate blood draws and tests in this case.
State?
Judge, I conferred with Mr. Bolsher. We are ready to proceed today, but I'm not objecting to his motion.
All right, so when was the expert retained for this?
He was retained, gosh, maybe 2 years ago, year and a half ago.
All right. So you need to find out from your expert when he's actually available.
We put that in the motion and the state conferred on 2 dates with us. So I think they were saying they were pretty packed on November 17th, and the alternate date, the state said that they would have all of their people was in February.
Well, no, I mean, it's saying that he's not available to appear October 14th through 17th. So
He has his appointments.
those when he has his appointments.
He
So,
also was given a home.
so someone needs to see for the court, and I need it in writing, whether or not he's available on the 20th.
October 20th.
Yes.
Okay,
I mean, no, we can start jury trial
Well,
this week. He
sorry.
just. So,
I understand.
all right, thank you.
Uh,
So you all, yes,
Sorry. I think in the motion, he said when he would be available. I think there was a date. I apologize. In his email.
I'm not sure. So the version that I had, it contained like an exhibit A that was attached. Does the court have that?
yes, I do. So we can still, it seems here. He says he's unavailable through October 14th through the 23rd. So y'all need to talk to him, and if he's available next week, we can do jury selection today and then continue it through next week.
I'll give him a call and come back.
Yes. Felix Beltran? Yes. Yes. So the last time you couldn't obtain discovery because the system, is everything okay with discovery?
Yes, we're good now.
Okay.
We are.
Yes.
May I approach her? This is the motion to reduce bond. I've shown it to Miss Galloway.
Mhm.
And I'll wait for her to get up here.
All right. And so this motion to reduce bond, that's only for one case?
Correct, Your Honor. The possession of a controlled substance less than a gram is set at 2,500 and well, it's not.
All right. And before we go on the record, what is the alleged offense date for the possession less than a gram? Is that before or after this case?
Yes, Your Honor, very astute. So the offense date on the less than a gram is 7/16. The ag assault with a deadly weapon has a 6/29 offense date, but it was filed at large.
Okay.
So upon execution of the aggravated assault warrant, he was charged with the possession on his person.
All right.
Et cetera, et cetera.
All right.
So he didn't pick one up right after the other.
Okay. All right, the court is calling 2025 CR 009628 State versus Felix Sebastian Beltran Jr. Could I have parties announced for the record?
Megan Galloway for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
And are you Mr. Beltran?
Yes, ma'am.
Do you have any objection to this attorney standing in?
No, ma'am.
All right, defense has filed a motion to reduce bond. Have you all had a chance to confer?
Yes, Your Honor.
State, are you in agreement to reduction of the bond?
No, Your Honor.
All right, then defense, it's your motion. Do you have any witnesses?
Your Honor, we would call our client, our defendant up, Mr. Felix Beltran, for purposes of bond reduction motion.
All right, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Felix Beltran.
All right, defense, you may proceed.
Thank you, Your Honor. Mr. Beltran, you understand why we're here today, correct?
Yes, ma'am.
Okay, and can you verify for the court that you've never posted bond on the $150,000 amount for the aggravated assault with a deadly weapon?
No, ma'am.
Okay, so you didn't post bond for the 150 and then pick up a less than a gram, right? Okay, so you have been in continuous custody since the offense date of the less than a gram, which is July 16th, 2025.
Yes, ma'am.
So that would put you at about 85 days of continuous custody at Bear County Jail.
Yes, ma'am.
Okay, okay. How old are you, Mr. Beltran?
23.
Do you have any children?
2 boys.
How old are they?
4 and 5.
Currently, where are they?
With their mother.
And does this case involve their mother in any way?
No, ma'am.
Okay. Specifically, Do you have a job or did you have a job prior to incarceration?
I work on my stepdad construction.
Okay, is that a small company?
Yeah, yes, ma'am.
Do you believe that if you were released, he would be able to employ you,
Yes, ma'am.
but consistently?
Yes, ma'am.
Okay. You are aware that there is a GPS condition attached to this bond?
Yes, ma'am.
And you understand that the judge could put you on full house arrest and not let you go anywhere?
Yes, ma'am.
Would you be able to would you be able to pay the $300 a month in GPS fees?
Yes, ma'am.
Would you be able to pay that?
After I get a job, yes, ma'am.
Okay, would you be able to pay that now upon
No.
release? Are you asking the court to respectfully consider waiving those fees?
Yes, ma'am.
Okay, do you own any property?
No, ma'am.
Do you have any bank accounts?
No, ma'am.
Do you have any cash on hand?
No, ma'am.
Do you have any jewelry that you could sell?
No, ma'am.
Do you have any vehicles that you could sell?
No, ma'am.
Is there anybody that could give you a loan?
My mother.
Realistically,
My mother.
aside from your mother?
Oh, no.
Okay, do you have any kind of credit line that where you think that you could get a loan?
No, ma'am.
Where do you live?
6211 Pioneer.
Is that where you would be going to live if you were released?
Yes, ma'am.
And final question, do you have anything to do with the alleged victim in this case, Joshua Scales, other than whatever could have happened?
No, ma'am.
Okay. You have any reason to believe that you would see him out and about?
No, no, ma'am.
Okay. Your Honor, that's all we have at this time. We've passed the witness.
All right, Mr. Beltran, at the time that this offense that you're charged with occurred on June 29th of 2025, who were you living with on that day?
My mother.
Okay, and if you are released from the Bear County Jail, do you intend to go live with your mother again?
ma'am.
Okay, and so at your mother's house, do you have access to firearms?
No, ma'am.
Okay, who else lives in your mother's house?
My brothers.
How old is your brother?
19, 19, 13, 8, and a newborn.
Okay, does your mom work?
Yes, ma'am.
What does she do?
Amazon.
Okay, do you know what her hours are? Okay, and then you said your dad does construction, is that correct?
Yes, ma'am.
Okay, and he receives, I mean, both of them receive checks for their work, is that correct?
Yes, ma'am.
Okay, have you or any of your family members reached out to a bonding company to see exactly how much you would have to pay to get out?
No, ma'am.
Or make the $150,000 bond?
No, ma'am.
Okay, and you've previously received a conviction for evading arrest or detention, is that correct? You have a prior conviction for evading, a misdemeanor conviction? Are you Felix Sebastian Beltran?
No. I didn't.
It says it's time served in the system. So, okay, you're saying you've never
No.
received a conviction. You were arrested for that, though?
Yes, ma'am.
Okay. We passed the witness, Your Honor.
All right, any further questions?
No, Your Honor, just to clarify, I don't know if I asked it, but he's 23.
All right. State any witnesses?
Judge, we didn't have any witnesses, but we would offer big exhibit B1 just for the purposes of this hearing.
No objection.
Then states exhibit B1 is admitted without objection for purposes of this hearing only. I have a few questions if there are no objections.
Question, yes, Your Honor.
All right. Have you ever had any type of mental health diagnosis?
As in,
Oh, have you ever seen a psychiatrist before?
younger. Not younger.
And were you diagnosed with any type of,
Bipolar and ADHD and ADD.
all right. And have you ever in the past used any type of drugs?
Yeah, yes, ma'am.
All right. And how often would you use in the past? And I'm asking these.
Every now and then.
Okay, and the reason why I'm asking these questions because I have to set conditions of your bond. Okay. So when is the last time you saw someone for mental health?
Since I was a child.
And when's the last time?
Middle school, like around 16, 15.
All right, so since that time, have you ever seen a psychiatrist or seen a doctor or been diagnosed with any mental health issues?
No.
All right.
I do have Tinder to defense, but it's you. That on the Tinder. There is one.
All right, any objections to states B2?
No, Your Honor.
All right, B2 is admitted without objection.
One of the evaders got dismissed, but there was a conviction.
Okay.
That's just, she was right when she said that there was a conviction on it. But you were right to be confused because one of them got done.
All right, court will hear argument.
Judge, we would just ask that you keep the bond amount at what was set by the magistrate, the $150,000, and you believe that it is sufficient to guarantee his appearance in court. And as far as the community safety aspect of it, we believe it's sufficient to comply with that. And so we'd ask that you keep it at what it's set at, Your Honor.
All right, and defense, it's your motion, so I'll give you final argument.
Very brief, Your Honor. I believe community safety can be addressed through the GPS system. I have no doubt that Your Honor will likely impose on the more restrictive end, which is fine. We do ask that you please waive the fees as testimony provided. He is indigent, to be honest. Our fees were more on the low bono side and have exhausted his parents' resources. You were able to identify some possible mental health conditions that he would abide by as a condition of his bond. And I think we can meet the safety requirements through other means other than the amount, because it is on the higher end. And after 85 days, I think we can believe that he cannot meet it. Other than that, Your Honor, we just respectfully ask to consider the reduction.
All right, and I'm so sorry. Could I see State's Exhibit B1 again, please? All right, the court is going to set your bond at $125,000. And counsel, if some reason he's unable to make that bond, you can file another motion.
Is there a time frame on that, Your Honor?
No. You just see if they can make that.
Understood.
All right, there's to be full GPS, waive fees, a referral to Center for Healthcare Services, outpatient treatment. Those fees will be waived. And that outpatient treatment is for substance abuse. And I'm sorry, instead of full GPS, it's going to be partial GPS, waive GPS fees, GPS until further notice, and the partial GPS for medical treatment and outpatient treatment only. There is to be no contact with the following.
We're fine, Judge.
All right, let me see if there's a date anywhere in here. All right, your plea deadline date, it's set in here for October 21st. All right, so you all will be back on October 21st.
Yes, ma'am.
Yes, ma'am.
All right, thank you.
Thank you.
Yes, ma'am.
Thank you. Mr. Marino, I'm going to send you to a breakout room. Your attorney will meet you there.
Yes, ma'am.
And who is here on Marlon Daniels? Thank you. All right, the court is calling 2024 CR 009219, 2024 CR 009218, State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
George Sharman on behalf of the defendant.
All right, counsel, I'm gonna need you to speak up so the court reporter can hear.
I'm sorry, George Sharman on behalf of the defendant, Mr. Marlon Daniels.
All right. Counsel, in each cause number, have you received all discovery and did you review it with your client?
We have, Judge.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Daniels, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
We do, Judge.
State and cause number ending in 18, are you proceeding on the indictment as presented?
Your Honor, and that cause number, the state is proceeding on count 1 and waiving count 2.
No
Any objection? And the cause number ending in 29, are you proceeding on the indictment as presented?
The state is proceeding on count 1 and waiving count 2, Your Honor.
No objection.
Right. Mr. Daniels, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause, you're charged with intoxication manslaughter. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea bargain in these cases?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Well, yes, we talked about that.
All right, do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Daniels, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
Off the record for a moment. All right, we're back on the record. And each of the cause numbers, according to the plea bargain agreement, punishment is to be assessed at 18 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There are no applications, and the cases will run concurrently, and there's $60 restitution to DPS. Did you understand that to be your plea in each of the cause numbers?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
In each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, are there many such motions?
No.
Then to count 1 in cause number 2024 CR 009218, how do you plead?
Guilty.
To count 1 in cause number 2024 CR 009219, how do you plead?
Guilty.
State in each of those cause numbers, is there any evidence to support the defendant's plea?
Yes, Your Honor. The state offers states 1 and attachments in each cause.
No objection.
Mr. Daniels, in each cause number, did you review the documents entitled waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after viewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in each cause number. Are we proceeding with sentencing?
I've requested a PSI on the case.
All right, what's the
We
purpose?
talked, I gave it to you last week.
No, I mean, what's the purpose of the PSI?
Well,
Do you not want me to follow the plea?
no, the purpose of it is for you to see the things that he's going to be doing. And it also helps to determine his, I guess, incarceration, what's going to happen to him there. And it gives them a basis of information about the case and about him.
But when he is incarcerated, they will do their process to see what would be appropriate, what treatment is appropriate for him.
I understand, but they have more things that they can do here to provide that information to the prison. And it's also a mandatory right that he has to
You know,
have.
I mean, if you want a PSI, of course, I will give you a PSI. I just don't understand the purpose of the PSI when you both have agreed that he's to serve time in custody.
Yes, and if you read the case law that I
No, I'm telling you, I understand that you're entitled to a PSI.
Yes.
I just don't understand the reason for it. I could see if I'm requesting a PSI because I've read the facts and maybe I'm not gonna follow your plea bargain agreement, but he's agreed to prison time. I don't understand the need for a PSI. That's what I'm just trying to understand.
right, and the point is that here locally, when they do the PSI, they have more information than the prison will have on his background, his military, everything that he's doing in the community here in his education. They will have more information to take with him to the prison. They will not have the ability to do the things that they can do here.
All right. It's the court's understanding that they do have the ability to do that. However, you want a PSI, the court will give you a PSI. Ms. Abrams, see if they can expedite the PSI. And I will give you a date. You're going to be taken into custody today. And let me call and see if I can get a date. All right. Is there anything else?
That's all we have.
All right. Thank you. Yes.
We did have family here for victim impact statements because it is an agreement. Is there any way that he can be sentenced and then just have the PSI done?
No, once a PSI is requested, the court has to have it beforehand. If they want to give victim impact statement by Zoom, they're welcome to do that. If there's no objection, I'll see if I can call probation and get this expedited.
Okay.
Fine.
All right, we can go off the record.
Thank you.
Okay. Jonathan Alfaro.
Judge, good morning. He's in custody. He was found incompetent.
Okay. Do you know when he was found incompetent?
I believe it was in May.
So have they sent him to the
Yes.
state hospital?
Yes.
So that's where he is now?
Yes.
All right, Ms. Ferguson, on this case, I'm gonna need he was sent in May. Just 1 second. All right, so this is probably gonna have to, let's bring it back our last week in December, just to see if he's regained competency. If not, it's probably gonna be another 180 days for him.
Yeah, we have him set in the magistrate court, June 26th of 26.
Oh, my goodness.
That's our next.
All right, let's, you know what, then. Now, I want to see, because sometimes they have that date, but then they'll get contacted by doctors at the state hospital and say, hey, they're competent. So let's do February.
Okay.
All right, February 16th. All right, state, Alfaro is going to be recalled for February 16th. All right. Jenny De La Rosa?
I've been confirmed with Megan. It's a trial case. I was just trying to figure out what my status was.
Oh, 1:30. for jury selection.
Austin
Where are you going?
to see the Lumineers. It's really important.
Oh, we'll, jury selection usually doesn't last.
Do I get credit for the two juries already picked here one week?
All right, so 1:30. Thank you. All right, James Francis. Doug Campbell said he's retiring.
Good work if you can get it, Judge.
So in this case, Mr. Francis, today is your plea deadline date. So have you all reached an agreement, or is
Judge,
it your
he's asked, he wants to fire me. He does not believe that I'm helping him. I negotiated a year.
Oh, no, I don't need to know the negotiation.
Judge.
This is what I'm telling you. Today is your plea deadline date. Your plea deadline date will not be extended. So my question for you is, are you reaching an agreement with the state or not?
No, ma'am.
All right, so then this is gonna. Regina Potts. Who's the attorney for Regina Potts? Court is calling 2025 CR 006643, State versus Regina Potts. Hello.
Hello, how are you?
All right, I'm doing fine. How are you doing?
It's great.
Can I have parties announced?
Eddie Garcia.
And are you Miss Potts?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Potts, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
And is your last name Potts or Potter?
Potts with an S, Potts.
Okay, so any objection to the court correcting?
No, not at all.
Okay. All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state it will move to waive the enhancement allegation.
Any objection? Ms. Potts, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property, less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Potts, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am.
If you're not a U.S. citizen, by entering this plea, you can be deported, not allowed to re-enter, and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's an $800 fine. State is recommending community supervision. They're taking in consideration 2025 PF 39082, 39083, 39084. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Target on Fredericksburg Road, the anti-theft course DOEP, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor, state offer states exhibit 1 in all attachments.
All right, state, you may be excused. Oh, and do you have for me to sign?
I'm sending to intake to.
All right, thank you.
dismissal that way.
Ms. Potts, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate
Yes, ma'am.
places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. The court has accepted into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court is making the following findings. Within regards to the police report, there's one officer who says that this happened on October 1st, 2024. There is another report that says that this happened on August 3rd, 2024. The court is going to find that the evidence is insufficient to find the defendant guilty of the offense as charged, and the court will find the defendant not guilty. So what that means with the finding of not guilty, then that means that the other cause numbers, those are still pending because I'm not taking those into consideration because I found you not guilty of this offense. I'm sorry, can I have the trial court? Thank you. And we can go off the record. What I can tell you is whatever your issues are, previously you told me while the state and the defense were speaking about the issue with the police report, you were telling me that you're former Air Force.
Yes, sir.
So there are plenty of places. This is supposed to be Military USA. There are plenty of places that can help you, but you've got to reach out to them. You understand?
Yes, ma'am.
Miss Abrams, can you see if Herman can come down just to give her information on where she can go to get the help she needs? She's military. All right, they're going to give you some information. All right, thank you.
Thank you.
You're welcome. All right, Juan Rios. 6 time is the charm. All right.
The call did not go as expected.
Oh, it did not?
I know, you can get on the record if you want.
Sure. Oh, what is it?
He's in hospital. He apparently has blood clots in his lungs. So when I called him and I sent Miss Galloway the text that he sent me of his hospital wristband. So I don't know when John Castle is going to be available at this point. I apologize.
Judge, he did provide me that information that you stated. So I conferred with him previously about dates that would work consistent with the Exhibit A that was attached to his motion, which was November 17th, I believe, is what the witness indicated the earliest that he would be available. So I did let Mr. Wilshire know that I do have a case that may proceed to trial on the 12th of November. So I'm not sure if that case will carry over.
All right, what page is this case on?
But November 17th, and then the other date in February, I believe we were agreed upon those 2 dates.
All right, this is what we're gonna do. Norma, recall this case for all right, this case is going to be recalled for October 16th. I'm going to need some better information on what the status is. And at that time, the court will make a ruling on your motion for continuance.
Thursday, Judge. See you here. 9
Yes.
a.m.
Yes,
Does Mr. Rios need to attend?
yes.
Just checking.
All right. Is there anything else?
Not at this point, Judge.
All right.
Kind of concerned that we might have to trouble.
Well, don't put that in the universe.
Yeah.
All right. We will see you back then.
Thank you.
You're welcome. Darrell Owens. Hello, come on down. So in this case, he also has a 2025 CR 010902. What is happening with that case?
TIC.
It's not written in the plea agreement.
We didn't say that, or?
No, I did, and I wrote it in the file as well.
Okay. I don't know. They're gonna TIC it later.
Judge, the misdemeanor is set tomorrow, so once that plea goes, I have the dismissal ready. It's just later on.
Okay. All right, the court is calling 2025 CR 010901, State versus Darrell Owens. Could I have parties announced?
Lauren Espinoza for the state.
And Richard Garcia for the defense.
And are you Mr. Owens? Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Owens, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the enhancement allegation.
No objections to that.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Owens, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? You're gonna have to speak up.
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
ma'am.
If you're not a citizen, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine. There are no applications. This is to run concurrent with 2025 CC 007863. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing it, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Excuse me, just 1 second. Deputies, could you all have them move? We're back on the record. Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence.
Yes, Your Honor, state offers states exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court is finding there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we are.
Anything you wish to say on behalf of your client?
We just ask that you follow the plea bargain.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CC 007868, and the court will recommend the therapeutic community. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, off the record. So the 902 case, when is that going to?
We're scheduled tomorrow for the County Court 5 misdemeanor case, Judge,
Okay.
which should be a time served, judgment satisfied. And at that time, they'll dismiss.
All right, Norma, recall the 902 case for 1016, and if that's already been done, then he won't be brought over.
Gotcha.
All right, do you have any questions?
No, ma'am.
All right, so here's the thing. If you don't get your life together, how old are you?
60.
All right, you're 60. You have more of your life behind you than in front of you. I can say that because I'm in the same boat. Unless you're
Okay.
planning on living 120. Okay, Richard, and I know your age, so we're both, all three of us. And wait a minute, let me see who else is here. I'm gonna call out names. Doug Campbell, you, Ernest, Mick, Louis, Norma. Yes, we all have more of our life behind us than in front of us. Unless we're,
Ready on French,
who else?
ready on French, ready on French.
All right, and so Ted Wood. All right, so you're gonna have to change your ways. Otherwise, you're gonna spend the rest of the life that you have on the planet in prison. You understand?
Can I say something?
Sure.
Only problem I downslide, as I just lost my mouth.
Well, here's the thing. When you think you're gonna downslide, that's when you go get help. You can't keep that to yourself, all right? All right, good luck to you, okay?
Thank you, Judge.
Thank you. Luis Frasinho. All right, so where are we on this case?
Your Honor, we got a plea offer today, which based on prior conversations with my client will likely be rejected. And we have all of our discovery, so we're ready to move forward to another set.
All right, I need a acknowledgement of discovery. And Norma, set this for a plea deadline date, the first week in November, please. All right, so you're gonna be back on November 3rd. At that time, you need to let the court know whether or not you reached an agreement. If you have not, your next setting is gonna be a trial date. Do you understand? All right, and here's the thing, court here starts at 9 a.m. If you're late, a warrant's gonna be issued. You understand?
Yes, Your Honor.
Unless there's a good reason for your late.
I do have a reason.
What's the reason?
My car messed up and I had a friend bring me over. She had to sign from the she was working from 4 to 1
Mhm.
and she had to post office. She had to sign the paperwork. I have it here where a copy where she signed to get out of work to bring me over here.
Okay, so here's the thing. That's why there's Via, there's Uber. You cannot be late for court. You understand? All right, once you sign the reset form, you're excused. Who's
Thank you.
next?
Hurry.
Elena Moreno. All right, today's plea deadline date.
Yes, Judge, we do plan on entering a plea today. We don't have an agreement with the state on this, however. So we're going to need to, I guess, go open to the court. We're going to ask for a PSI.
All right, so I'm gonna have you all do the paperwork and I'll take up your plea at 1:30.
Okay, thank you,
All
Judge.
right, thank you.
241.
I don't want to steal anybody's thunder.
Yes. Yay.
Which is a positive, right?
That is, yes. Okay, I am glad that you're on the right track and thank you for being honest with me. So. 6, 5, 7, 9. So what is it you need from the court to be successful?
Honestly, I would, if anything, if I could redo those classes, the outpatient classes with Ms. Smith, because those really helped me. Those really helped me. It's just, I got a little off track with an ex that I had been involved with, and I kicked him to the curb finally for good once and for all.
Yay.
So, yeah, I would rather do those again with Ms. Smith, if I could, please.
All right, Ms. Abrams, is it possible for her to do, she wants to do the outpatient again, but with Ms. Smith, is that possible?
I can request it. I can't guarantee it.
We'll do the praying hands for them, please. All right, is there anything else you need?
That's gonna be it. Thank you very much for listening.
Is there anything else you think she needs probation?
The recommendation that was listed on the court summary was for her to do felony drug court evaluation. If we're gonna go the intensive outpatient way, I would recommend possibly sober support meeting.
Okay. So this is what I can tell you, and your attorney will be able to talk to you. I'm gonna give you a choice. Felony drug court is a great program. Felony drug court, actually based upon your offense, if you complete it successfully and you graduate, one, I'll show up to your graduation the tree you're on, but they will also terminate you early for completion of felony drug court. But it's very intensive, right? Or if you want, I can place you back in outpatient treatment, but I'm gonna require sober support meetings. And what we can do with the sober support meetings is for every support meeting she does, you can take off an hour of her community service restitution.
Okay, Judge.
So what do you think would help you maintain your sobriety?
Knowing that you have a full-time job.
I think let's do the drug court thing, because it's probably gonna be as intensive as the outpatient classes will be. So I'd rather take that gamble to do the early termination if possible, if I can think that.
All right, let's then do a referral to felony drug court.
And if not accepted, intensive outpatient
Yes.
treatment.
Okay.
Sounds good.
All right, thank you so much, and keep up the good work, okay?
Yes, ma'am.
All right, thank you.
Would we be excused?
Yes, well, they're gonna have some conditions for her. Michael Rivera. All right, where are we on discovery?
So this is an MTR case, Judge, and
Wait, I don't have the motion to revoke.
oh, do I? I'm sorry. You want that? You want the?
All right, so this is gonna have to come back at 1:30.
I mean, it's gonna be quick because I got, he's on an MTR and I have the complaint and I got the judgment that I provided to the state.
Okay, I'll have you all come back at 1:30. Who's next?
1:30.
Who's next?
I can't come back at 1:30.
All right, James Francis. Court is calling 2025 CR 006-564 and 2025 CR 006-565. State versus James Francis. Could I have parties announced for the record?
There's Ted Wood for Mr. Francis. It's Ms. Albin for the state. I guess.
Megan Galloway for the state.
All right, are there any applications?
No, Your Honor.
All right, and each cause number, counsel, have you received all discovery? Did you review it with your client?
Judge, I reviewed the discovery except for the media players. I don't have a portable computer to bring in here, so provisionally all the paperwork was reviewed, but not the videos.
All right, do you have any objection with continuing?
No, I don't.
All right, in each cause number, the court will find that the state is in compliance with discovery. Mr. Francis, sorry about that. And each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
I do.
State in cause number 2025 CR 006564, it appears that you're proceeding on the indictment as presented with the repeater allegation enhancement.
Yes, Your Honor.
And in cause number 2025 CR 006565, it appears that you're proceeding with the repeater enhancement allegation. Is that correct?
Yes, Your Honor.
Mr. Francis, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If the state presents information or evidence to the court beyond a reasonable doubt that the enhancement allegation is true, your range of punishment will be anywhere from 2 to 10 years in prison and up to $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Are you on, is he on probation out of this court?
I don't believe so, Judge.
Because off the record, part of your agreement is to run concurrent with 2025 CR 006565.
Yes, Judge.
Has he been sentenced on that case? Oh, it's the same cause number. I'm so sorry.
That's
It's
all right.
already
I
been
knew
a
you were
long
gonna
day.
figure it out.
Thank
You're
you,
gonna
thank
figure it
you.
out.
164.
All right, we're back on the record. Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Judge,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr. Francis, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into these plea bargain agreements, you could be deported, denied naturalization, and denied re-entry into the United States. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine, no applications. The causes will run concurrently. The state will take in consideration 2025 CR 007325, 2025 CC 005191, 2025 CC 011658. Did you understand that to be the plea?
Yes, ma'am.
Defense?
yes,
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each cause number with your attorney? Did you understand it and sign it?
No.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
no, Judge. And Judge, may I inquire the court? I just filled out paperwork on waiver of appeal on 6565. Do I need to do another set on 6564?
No, it's in here. You
Okay,
mean the
but
waiver of appeal
the-
paragraph, or
yeah,
you're
the-
talking about the trial court
Trial
certification?
court certification.
Yes, you'll need to do one on that.
Thank you,
one.
Judge.
All right. And cause number 2025 CR 006564, how do you plead?
No contest.
To the enhancements, how do you plead?
No contest.
No, either it's true or not true.
True.
Excuse me, sorry. And cause number 2025 CR 006565, how do you plead?
No contest.
To the enhancement, how do you plead?
No contest.
True or not
True,
true?
true. I'm sorry.
State any evidence to support the pleas?
Judge, may I see the stipulation or the stipulations, please?
Sure.
Judge, you have trial court certification on 65 or 64?
65.
Okay, thank you, Judge.
Okay, the state offers states exhibit number 1 in each cause, Your Honor.
No objections, Judge.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
No.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
No.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the court is going to find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, your back office informs me that he has 91 days back time. I'm asking that be applied to his sentence. That the time and money to run concurrently. And Judge, I'm asking that you, I know you don't have that much control, but I'm asking that you put a request in for therapeutic community. I think that Mr. Francis is salvageable, but I think he may need some help.
Is there anything you wish to say, Mr. Francis?
No, ma'am.
All right, so this is what the court will do. The court will follow your agreement. The court will sentence you to 3 years in the prison. There's $1,000 fine, time and money to run concurrent. This will run concurrent, and this is in cause number 2025 CR 006564. This case will run concurrent with 2025 CR 006565. Take in consideration 2025 CR 007325, 2025 CC 005191, 2025 CC 011658. And the court will request a therapeutic community. I do not have jurisdiction for them to place you in that program, but they'll see it in the judgment that I think it's appropriate. So you'll have to ask for it as well. Do you understand?
No.
And cause number 2025 CR 006565. As previously stated, the court is finding you guilty. The enhancement's true based upon your plea of true and based upon state's exhibits and attachments. The court will sentence you to 3 years in the prison. There's $1,000 fine. Time and money will run concurrently. The court will run this concurrent with 2025 CR 006564. Take in consideration 2025 CR 007325, 2025 CC 005191, and 2025 CC 011658. Is there anything else in that cause number with regards to sentencing?
No, Your Honor.
All right, in each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So when you came up to me before, you were saying that you have a drug problem and you need help. You need to remember that. You need to internalize that. When you go to the prison, request the therapeutic community. When you're released from prison, if you can't find a sober support home, or if you can't find a place to get help for any drug addictions you may have, come to this court. If I'm still here, I'm gonna pick up the phone, call somebody to help you, all right? All right, good luck to you, okay?
Thank you.
You're welcome. All right, Charles Fleming. Where's Mr. Fleming?
Right here, Judge. Come on up, Mr. Fleming.
Have you conferred with the state?
Judge, there were some concerns that probation had. I set up a visit with him on October 3rd and he did not show up. And so, based on what probation have put in their report, I'd like to have it evaluated. So,
All right, Ms. Ferguson. There needs to be a competency evaluation on Mr. Fleming.
yes, I will. Thank you.
All right, so Norma, recall this in 1 month so we can get an update on the competency. Court is calling 2025 CR 01075 State versus Dorian Murphy. Could I have parties approach and announce for the record?
Jim Oltersdorf for Dorian Murphy. Come on up here and Stand in the middle there for me.
And are you Dorian Murphy?
Yes, Your Honor.
All right, you entered a plea of no contest. According to your plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. The state opposes your application. Parties waived PSI. Are there any witnesses from either side?
Judge, the witness that would be presented to the court would be the defendant himself, Mr. Murphy. He's told me that before we approach, that people that he was thinking about calling were busy at work, and that he would like to go ahead and proceed by himself. He doesn't want to reset to bring them up to be heard before you at a future date. Is that correct, Dorian?
Yes, sir.
All right. So state you're opposed?
We are, Your Honor.
Yes.
We're gonna rest on the contents of the stipulation. And argue to the court after defense puts on their case.
All right. Any evidence you wish to
May I
present?
call Mr. Murphy?
Yes. Could you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Dorian Latrell Murphy.
Dorian, I'm gonna ask you some questions. I want you to kind of answer in the direction of the judge, even though I'm standing next to you. She's the one that needs to hear your answers. And of course, when I finish, the young lady to your left, to your right, is going to be allowed to ask a question on behalf of this district attorney's office, okay?
Okay.
Dorian, do you have any kind of job situation
Yes.
lined up? Would you tell the court about that?
I was working at Komori over there in 1604 in Calabria, along with Bowl and Barrel on near Lock and Terra area.
You said Bowl and Barrel was the second one. What was the first one?
Komori.
Komori?
Yes.
Can you spell that?
Kumori.
What is that
A
exactly?
Japanese cuisine, sushi and steakhouse.
What kind of work were you doing over there?
I was a cook, a line cook
How long had you been over at the first place, Komori?
for about 7 months.
And was that a full-time job?
Yes, sir.
So you were a cook, full-time job, making the different dishes that they served over there?
Yes, sir.
Say the location again for us.
I was near 1604 in Calabria.
Thank you. What was the second place? The
Bowl and Barrel over there.
Bowl and Barrel.
And Lock and Terra was a dishwasher.
Okay, what kind of place is that? Is that a big restaurant over there?
It's slash restaurant and then collided with a bowling alley.
Okay, so that explains the bowl part.
Yes,
Okay.
sir.
How long had you been over there?
For 4 months.
And that was a dishwashing job, you said?
Yes, sir.
Now, if you were released to be on probation, is that the type of job skills that you possess as being a cook?
Yes, sir.
And it sounds like are you restricted to just one type of restaurant, or could you go to any other restaurant?
I
And
could
if so,
go-
what would those be?
I could go to different types of locations. I can go to Aston's Creek over there on 1604. I could go to PF Chang's on Lock and Terra. And I believe one more, but I can't remember at the top of my head currently.
How old are you now?
I'm 27.
How long have you been engaged in that type of work?
Since I was 18.
Did you finish high school?
No, sir.
Was that here in San Antonio?
I was homeschooled.
Oh, okay. Now, what kind of support do you have if you're released from jail?
My mother, my grandmother, my uncles, and my aunts.
Are they here in San Antonio?
Yes, sir.
All of them?
Yes, sir.
Now, have you talked to them about it? If you were released, could you just suddenly appear at their door and be able to at least have a place to sleep and eat and report to
Have a
probation?
place to sleep and everything, and then potential job opportunities lined up.
So you'd have a phone and everything where you could answer those questions that if you put in an application, you'd be available to get right on those jobs, right?
Yes.
Okay. Do you have transportation?
Yes.
How would that be arranged? Is that you or your mom or who is that?
Currently, it would be with my brother.
Okay. To get to the jobs, right?
Yes, sir. If
What,
not, then public transportation such as the bus.
so do they live, what part of town roughly do they live in? You're talking about all these restaurants?
Northeast side for my aunts and then my uncle, and then northwest side for my mother and my grandmother.
So some in the proximity of the restaurants that you're referring to, although,
Walking distance, yes, sir.
okay, thank you. tell us a little bit, this case, you freely entered into a plea on this case. Do you have any remorse? What's your position about what you did
I had a
wrong?
lot of time to think about my actions and know that I need to have a better handle over my tongue. Know that there are consequences to my actions as well. All I'm asking for is a second chance. I know what I said and everything was wrong, and definitely took this opportunity as a learning experience.
This was a bunch of threats to a some type of a I don't know. I'm not familiar with it. I know the
The
name.
Cash App chat bot, sir.
Yeah, I don't know how that works, but let's don't get into that. But you were frustrated for some reason. Is that what occurred here?
Yes, sir.
And it was because you thought that something had occurred that you had been
For
taken, excuse me.
My money being taken away from me.
Okay,
But I was mistaken on it. I should have waited and evaluated it before speaking.
okay. So you deeply regret what happened.
Yes,
You've
sir.
also had a little bit of a history too. We went over that before we ended our plea and everything, right?
Yes, sir.
You seem like you're the kind of person that might not have a drug problem. Do you have a drug problem or not?
Only with THC weed, but it's not, I've never had a problem. I can go off of it when needed to, and I plan to. I've been clean this long, so
So addiction wise, meth, cocaine,
I don't have any drug problems with
Okay.
those.
so, okay, just the ones that would be of an emotional or a nature that would be a stabilizing type of drug, even though it's illegal, right?
Yes, sir.
And you would be willing to stay off that, correct?
Yes, sir.
The judge would order it if you're on probation. You understand that?
Yes, sir.
No, there would be consequences if you turned up with any of that in your system. Do you understand that?
Yes, sir.
Understand that in the job environment, that might be available. I'm not saying it's in every restaurant, but it might be, you might be around people that would have that and tempt you with that. Would you be able to resist that type of approach? Somebody
sir.
tempting you?
Yes, sir. I would be able to resist and make sure to stick to what I'm needing to keep myself stable and out of jail and doing the things that I need to do to take care of my family.
Is there anything that the judge needs to know that I have not talked about that you feel like Her Honor needs to know?
No, sir.
Okay. You seem very well spoken for someone that, when you say you're homeschooled, but you didn't finish high school, you certainly don't sound like that, in my opinion. Do you read a lot or how
Yes,
do
sir.
you?
I read a lot. I'll go to the library occasionally, pick up books. I like to read. Knowledge is power, I believe, so.
Thank you. The young lady I spoke to you about, please answer her questions with the appropriate, polite answers and listen to her questions, okay?
Yes, sir.
Pass away, Sean.
All right, stay.
Yes, John. Mr. Murphy, how much money was it that you were so upset over?
I believe around $63 at the time.
$63.
Yes, ma'am.
So you threatened to shoot up a gas station and kill a bunch of people over $63.
Yes, ma'am.
You said that you understand that your actions have consequences. Have you considered how the individuals who were made aware of your threats may have been affected by hearing that you were going to come do that to them?
Yes, ma'am.
And if the roles were reversed, if it had been you that had been threatened by someone that you don't know, who made statements that they were capable, not only were they going to do these threats, they were capable of carrying out these threats, how would that make you feel?
Unsafe and not too pleasant. Very, very upsetting and troubled.
And you do have a little bit of a history for assault, do you not?
Yes, ma'am.
When you were a juvenile,
Yes, ma'am.
you were placed on deferred adjudication or deferred prosecution for assault public servant
Yes, ma'am.
and assault against a family member.
Yes, ma'am.
One moment. Given your history for violence and your apparent short fuse, what assurances does the court have that if she grants you probation, that you won't have a short fuse again and commit an act of violence as we know you're prone to do?
Me doing the time in the bid that I've done now, I'm having a lot of time to think. I also have a newborn, going to be born on November 14th. A lot of other variables from family and just evaluating my life that's going to make sure and ensure that I need to get a tight grip and a tight handle on the situation before I speak and before I act.
Nothing further.
One last question. Going back from today, how long have you been in the jailhouse?
About 4 months now.
Thank you. There's no further questions or witnesses.
I have a couple of questions if there's no objection.
No objection.
Oh, sorry, no.
All right, this is what I'm trying to figure out. Why did you text them and tell them to look my name up on Google for capital murder? So was there ever a capital murder involved?
I haven't Googled him, Your Honor.
And I'm just, what's in the stipulations? You sent message and you said, look my name up on Google for capital murder. So has anyone done that?
I'm thinking there was a charge, but I know it never went anywhere, but I can't remember exactly. I remember asking him about that. And I don't know if that was a mistake. We didn't pursue it because the DA didn't seem to know anything. But I didn't talk to this district attorney about it.
Okay.
But it didn't appear to have anything. I mean, if it was here in San Antonio, I remember that. Is that what you're seeing, Joe?
No, I mean, it just says, I haven't Googled anything. I'm just going from the
Oh, no.
stipulations.
It did.
I saw it in their
It says
file.
That there was a charge that was dismissed.
Yeah.
Okay. And then, so there was a previous charge against you for capital murder
Yes, Your Honor.
that was dismissed?
Yes, Your Honor.
Okay. And mind you, I'm not taking into consideration that you have a capital murder that's been dismissed because that was dismissed.
Yes, Your Honor.
I'm just going through what's in the stipulations and I'm trying to figure out whether or not you would be appropriate for probation or not.
I understand, Your Honor.
Then what is this? When I get arrested, the news asks why I shot up the store and everything. I will let it be known that I gave y'all a chance, literally stealing money. So why did you think they had stolen your money?
At the time was when I had swiped my card, it had gave me 2 different transactions. One was not one that I had made.
Mhm.
I tried to talk to the staff at the time.
So what was the transaction for? The first transaction that you think you didn't make?
The $63 one, the one I didn't make, I originally just bought in a little vape, maybe like $15-20. Then I was previously, or right after, shortly charged 63, somewhere roughly around the 60s for another charge that I tried to talk to them. They gave me the runaround and I lashed without thinking and talking.
So what ended up happening to the $630 that you said you were?
Never got it. So,
But it was never charged?
no, it was charged. I'm still negative on it, but I've never got it back. I wound up talking recklessly and then shortly after I got incarcerated.
All right. Any other questions?
No.
All right, the court will hear argument.
Your Honor, I'll reserve.
Judge, I know this is not real important, but I've represented over a long period of time a lot of people that I thought when I gave them a push down the road on probation would probably be back in front of the judge. And this gentleman, since the very beginning when I met him in the jail to now, has acted like he just lost it. And it seems like the kind of his representation of and explanations to me have been much more profound and of depth than the average person that appears, as I've appeared with in courts for many years, where they're just trying to get out of something. I think he just had a really bad slip up. I mean, that's probably not a good way of putting it, but I realize that the only way you can think about it is to wind up with 4 months in jail over $63, but saying a bunch of terrible things over it is pretty bad. I just think from what I've heard him talk about his job history, I didn't know much about that till today. I'm impressed by the fact that I think he can be a contributing member of society. I guess the best part about this guy, when I come back to the beginning of what I began talking to you about my time in this standing here, in front of judges, is his insight. I think he's got more insight than the average person that I have, over the years, where I thought they were gonna be fine. I think stronger about this guy than I thought about them. I think he's figured it out. I think being in jail has probably, I'm guessing, been
A
a real
wake-up call.
been a real eye opener to Mr. Murphy.
But here's my question. You're 27.
Yes, Your Honor.
How old were you when this occurred?
26.
All right, so you were 26 and you have this juvenile history. Why wasn't that a wake-up call?
It was been years since I believe I was 13 or 14.
And
I
then,
was still young, didn't understand. So after sitting here for the time that I've sat and the seclusion from being outside, restrictions on access to things, just really an eye opener.
and let me just tell you, this is my problem. Well, not my problem. This is just something I'm going to tell you. The threats you made, it could have been $63, it could have been $100,000, but according to this, your threat starts at 10. I mean, you're 20, you're in your late 20s. It's not as though you're a teenager. So they start at 10 and you continue all the way to 105, telling people that you're going to show up at the location, and you put the specific location in there. It starts with the initial threat they said was, if I don't get my profanity and say 3 hours, I'm pulling up to the store and shooting the place up. And you said it's 10:05 a.m. You got till 1:05 p.m. And then after that, you didn't even give them to the 1:05 p.m. deadline. Then after that, you tell them to look up your name and Google it for capital murder. And I would think that if you had grown from your juvenile days and you know that capital murder has been dismissed, you wouldn't even be bringing that up. But you just like, Google my name with capital murder. And then you come back and say, look, if I don't get my cash back by 1:05 p.m. today, I'm pulling up to that store and I'm shooting the whole effing place up. And then you say, I will crash TF out and go to jail and post this on media. Y'all had a chance. And then when I get arrested and the news asks why I shot up the store and everything, I will let it be known that I gave y'all a chance, literally stealing money.
Yes, Your Honor.
I just don't think you're appropriate for probation. There's the criminal history. Then it would seem that once you're sending these messages, you would step back and think. And then the fact that you have a capital murder dismissed, and mind you, I'm not taking that as true, but for you to say, hey, Google my name with capital murder, like what frame of mind are you in when you do that?
I was out of state of mind for it at the time, Your Honor.
Okay. What I can tell you, I don't think you're appropriate for probation. I don't know if he has any convictions that will preclude him from being eligible for shock probation, because I don't have his complete history, but I'm going to find you guilty. I'm going to sentence you to the 4 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. You can't have any contact with any Shell station. And I don't know his criminal history, so.
Are you?
The adult side, Your Honor, I can tell you from what I can see, he has, I just lost my page. I believe he has a misdemeanor theft. Yeah,
Mhm.
he has a conviction for misdemeanor theft and misdemeanor ABI family.
All right, so counsel, you can, I'll retain jurisdiction.
Would you please make a note of that, Your Honor?
Oh, my mind's a steel trap. I'll remember it. Yes.
I may not.
Okay.
That's what I'm saying.
All right, I'll make a note.
Maybe you can let me know, and
Well, I'll retain jurisdiction.
because the court usually asks for a report
Mhm.
in in advance, just to alert the court to that.
Okay.
That's why I'm asking about the note.
Yes,
And if the court reads that report and then decides whether to bring him down,
yes.
it's already in the, you know how it works.
Mhm.
Thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're welcome.
The number that you paid for the four?
Yes,
You know, leaving 6 months.
I followed the agreement. Christina Taylor. Thank you. Court is calling 2025 CR 010464, State versus Christina Anna Marie Taylor. Can I have parties announced?
Yeah, it's your partner's brother.
Melissa Albin for the state.
Defense.
Mick Aguilar on behalf of the Honorable Christina Taylor.
And are you Miss Taylor? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Probation, there's no application. Ms. Taylor, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, you're proceeding on the indictment as presented, correct?
I believe so, Your Honor. I have to
Yes.
indictment. Yes, we are. That's correct.
All right. Ms. Taylor, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Very much so, yes, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Taylor, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-enter into the states. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility. There's a $1,000 fine, no applications. The state will take in consideration 2025 PF 30332 and 2025 CC 011643. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor, there has not.
Then to the offense as charged, how do you plead?
No, no. Tender.
All right. State any evidence?
State offers into evidence states exhibit 1 with its attachments.
And Judge, we've had the opportunity to review those exhibits and have no objection.
All right, state you may be excused.
Thank you.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
If you would consider it, yes, Judge.
Anything you wish to say on behalf of your client?
Judge, I just think that she's making the right choice today. She does have 105 days in custody. If you give her credit for that time. I explained to her that she still owes the state jail 75 days. And then if she took a life skills class, which I think they teach you to boil water, iron shirts, then you would consider giving her a 20% discount on that after completing that class. She said that she'll go to the state jail, but didn't really want to give a class.
All right. Okay. Court will follow your agreement. The court is going to find you guilty, sentence you to 180 days in the state jail facility, give you credit for any time served. There's a $1,000 fine. The court will take in consideration 2025 EF 30332 and 2025 CC 011643. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I can recommend therapeutic community for you. It doesn't increase the time that you're in, but hopefully it can help you get on the right track where you can become sober. Because if you don't, I've read the police report, what's going to end up happening is you're probably going to end up dying, or either you're going to end up in prison for the rest of your life. Because the drugs you're using, any drugs, right, are dangerous. But what you're doing, it's not good for your body. It's not good for your health. It's not good for your brain. It's going to attack every part of your body. And you don't want, do you have family here?
Yes. I grew up in Toma County.
All right. Do you have anybody here in San Antonio as a support system?
Not,
I believe there's somebody in Cibolo, Judge.
yes, Cibolo, my sister.
All right. Do you have any children?
No,
All right. Mom, dad?
mom, and I don't know where my dad is right now. I do have my mom in Florida. I was considering moving out there with her.
Mom's in Ellington, Florida,
Mhm.
and then my notes here have their dads in.
Right.
Okay.
Thank you, Judge.
I'm just sort of scared of prison.
Well, here's the thing. That's right now, that's probably the best for you. And the reason why I say that is because you're not, the last time you use could be the last time you use. And then you know what would end up happening? Your body would be found. Your mom, your dad, or your sister would have to identify you. So you're going to have to get major help when you're released from the state jail facility. If I'm still here, you come here. I will pick up the phone. I will find a sober support living house, place for you to live because you really need the help. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, Judge.
You're welcome. Mr. Moreno, just give me a thumbs up if you're able to hear me. The equipment is not working on our side. All right. So what's going to happen is we're going to recall your case for October 23rd. The state said they'll have an answer for your presentation of their counteroffer. All right, so we'll send you back, and Deputy Laura, if it's best for him to be by Zoom, that's fine. All right, thank you.
Thank you, Judge. Thank you, Judge.
You're welcome. Kenora Adams. And there's an application.
Yes.
Probation, this is an application. Court is calling 2025 CR 0100958, State versus Kenora, LaShawn Adams. Could I have parties announce?
Kelly Biddle for Kenora Adams.
And are you Miss Adams?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Miss Adams, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, I'm sorry. State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Ms. Adams, did you review? Just
Yes.
1 second, sorry. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Adams, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
All right, there's. If you're not a US citizen by entering this plea, you will be deported, denied naturalization, and re-entry into the states. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. There are no applications. State recommends deferred adjudication. This will run concurrently with 2025 PF 40428. The state will take in consideration 2025 CR 010957. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution, no contact with the complainant or 7-Eleven, MIC evaluation or referral to Center for Healthcare Services, MRT, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plea?
No contact.
State, any evidence?
State Office States Exhibit 1.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and stipulated to stipulation of testimony. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Please.
All right, anything you wish to say on behalf of your client?
Just asking you to follow the plea bargain, Judge. In addition, if the court would consider probating all unfortunately defined due to indigence.
All right. When's the last time you had employment?
Been a couple years, but I work for myself.
When you say you work for yourself, what do you mean? What do you do?
Investments. Make investments in the stock market and crypto.
All right, so then why were you at the location taking items from 7-Eleven?
It didn't quite happen that way, Your Honor. I had court that very same day. My bodysuit had broken and they had rescheduled my court date that specific day. McKinney explained to me that I couldn't walk around with my bodysuit like that, so he sent me home with the paperwork. When I got home, well, not home, but I got to the San Antonio Dodge dealership where my spouse works. They called me and told me I had a warrant out for my arrest. And so I was sitting at the McDonald's a couple of doors down while he finished up working. I was stressed out because I was trying to figure out, like, how did I have a warrant out for my arrest when I was already at the court for the court hearing. So I had to call the court. They gave me the runaround, had to get it rescheduled. They rescheduled me for the following day. And so I ended up walking over to the 7-Eleven, Your Honor, and I ended up grabbing a Coca-Cola, and I left my wallet at the McDonald's that was next door. I expressed to the manager that I was going to be right back, and he like assaulted me as I told him I was going to come back. And me and him got into a scuffle. I didn't steal anything, Your Honor. And so I ended up hitting him after he assaulted me. There was a guy in the way, and they broke us up. Now the retaliation charge came in because I came back with my wallet to show him, like, hey, I don't need to steal anything. I was just having a bad day because I had a warrant out for my arrest the same day I had went to court. And so he ended up calling the cops on me because we had already gotten to a scuffle.
All right, so the police report is saying that you left the store without paying for the merchandise that you took.
No, Your Honor, I got right outside. We got really right in it. We were at the door. I didn't leave the store with the.
Well, I mean, once you pass points of sale, so the register is here. If you pass that register without paying for it, that's passing the point of sale. So that's why you're charged with robbery. So do you want the court to accept this plea or do you want a jury trial?
My only concern, Your Honor, is I've been sitting in jail for 4 months. And I want to get out, so.
No, here's the thing. I don't want to accept any pleas because somebody wants to get out of jail. Your attorney can always file a motion for a bond reduction. I will hear it. What I can tell you though is with the way the new laws are, if it's a violent offense, you're not eligible for a PR bond, so that's off the table. So it's completely up to you. Yeah, what I can tell you is what I've read, the stipulations, when that is entered, that means the reason why they call it the waiver and stipulation to evidence is because you're stipulating that everything is in there that is true and correct. And you're stipulating that if the witnesses were to come in and testify, they will say exactly what's in the police report to meet the elements of robbery.
I'm okay with that, Your Honor, because everything's on camera.
Well, no, I mean, it's up to you. If you want a jury trial, then we'll set it for jury trial. Do you need to discuss with your?
Set for trial in 2 weeks.
Well, I don't know if it's going to make it in 2 weeks because we have,
We'll try.
the reason why I say that is because we have murder trials and capital murders that are set, that are before this case.
Sure.
And this case, it is,
As soon as possible.
all right, because this one is alleged to have been committed on or about June 16th, 2025. So there are cases that are older than that will be before her. So is she withdrawing her plea?
Yes, Your Honor.
All right. So if you'll speak with Ms. Ferguson and we'll set it for trial. Norma, if you'll give them a jury trial date, please.
Judge, I can do it December 9th.
All right, December 9th. Who's here on Claudel Carney? Are y'all proceeding with the motion to revoke?
Looks like it's gonna be a contested motion.
Well, I mean, is it contested?
It is. Specifically to the new number 1.
All right, this case has been contested, set for contested previously on other things. And then there's always at the end, I think, a plea or a waiver. So is this really going to be a contested hearing?
I think it will be this time, Your Honor, yes.
I mean, no, that's either yes or no.
Yes. It will.
All right, Ms. Ferguson. How long have you been on this case, counsel?
This is my first say. I've met with him in the jail. It's,
No, I mean, how long have you represented him on the motion to revoke?
oh, more than 10 days.
All right, Ms. Ferguson. Recall this for Thursday for contestant. Yes. Ms. Abrams, this is gonna be a true contestant and it's coming back on Thursday.
You want morning or afternoon? Judge?
If you'll speak with Ms. Ferguson, she'll let you know.
Okay, thank
All right, thank you.
you.
You're welcome. Hello, where's Mr. Vasquez?
Ready.
Oh, come down, please. Hello. All right, so we were coming back for, let me see, the video was received? No, still.
Your Honor, we were discussing and I had asked if he could help me narrow down which video precisely it is, whether it's like Investigator Limon or Luna. However, I know on there and it's not labeled as it is under ours, so I'm gonna need to download everything to watch it. I just haven't had the time to do that.
Okay.
And specifically, I have several videos. What I'm looking for is the very first officer to arrive at the scene.
Okay.
And the way when I download the information, it doesn't label the name of the officer, it's just some data that's associated. The computer gives like some sort of
Real name, it's just numbers. and-
ABC, so I can't tell who his officer I already have.
All right, how much time are you all requesting?
Your Honor, I would just ask for like a 2-week reset to get this sorted.
All right, Ms. Ferguson, I need a 2-week reset for discovery.
That's good. I can do the 30th.
All right, we'll be back on October 30th. That's for your attorney to get the discovery he's requesting.
Judge,
Yes.
I apologize, I have a murder issue in Hondo on the 30th. I have to
Okay.
meet with an inmate who's in TDC.
All right, at least you didn't tell me it was for a criminal trespass.
No.
No, okay. All right, the 28th.
28th, Judge.
All right, 10/28. Who's here on Elena Marino?
That would be me, Judge. We're ready.
All right. Court is calling 2025 CR 005594 State versus Elena Marino. Could I have parties announced?
Lauren Espinosa for the state.
Hedrick A. Hicks for the defense.
And are you Elena Marina Sanchez?
Yes, ma'am.
Counsel, you received all discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Sanchez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Sanchez, did you review the document entitled Court Admonishments and Defendants Waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with theft of property, $30,000 to $150,000 as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand?
Yes.
By entering into this agreement to enter into an open plea to the court, you're giving up those rights. Did you understand? And did you intend to give up those rights and enter into a plea, an open plea to the court? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea that you could be deported? Well, not deported. You will be deported, denied naturalization, or re-entry into the United States. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. And it's the court's understanding that there is no plea bargain in this case. You are entering a plea to the offense. The state will provide evidence for the court to review, and the court will decide punishment. Is that correct? Is that correct, state?
That is correct, Your Honor.
Is that correct?
Yes,
I'm sorry, defense. State, is that correct?
Yes.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offer states Exhibit 1 and all attachments.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. And do you all wish to set this for a PSI?
We do, Judge.
All right. I need a reset date for a PSI. And for, is there a top evaluation needed?
No type of evaluation, Judge.
And we can go off the record. What I can tell you is there going to be any funds?
That's what we are hoping to have made available for our sentencing date, Judge.
Okay. And that will need to be brought in the form of a cashier's check or money order. And is that a money order cashier's check for the separate complainants, or?
Yes, Your Honor. It would be 16 separate complainants that I have the amount of names readily available.
All right, so if you can make sure that, and so the cashier's check will need to be made out to those complainants individually. All right, what date? All right, we'll be back on December 9th.
And just one quick question for the court, Judge. PSIs, have they been coming in around this time or something? I just want to make sure.
Oh, no, the PSI will be done
Okay.
on that.
Okay.
Yes.
I just want to confirm. I've been hearing various different, anywhere from 4 weeks to 12 weeks. So I just want to.
Oh, no, it is 4 to 12 weeks, but sometimes it's here sooner than that. So Bashan is saying, yes, we will have
See
it.
that look?
Yes.
Look at our face. I just wanted to confirm. Thank you.
Yes. All right. Thank you. Once you sign the reset form and speak with the probation officer, you're excused.
All right.
Thank you. You're welcome. All right. Fidencio Gonzalez. All right. Yes, Mr. Hernandez.
Yes, Your Honor, we filed a motion for continuance in this matter over the break.
Okay.
It has been e-filed,
Okay.
and I believe it's actually been accepted.
Okay.
Our arguments, essentially our understanding was that this was a plea deadline setting today
Okay.
and wasn't necessarily a trial setting. And as such, we're asking for a continuance on the matter.
All right. State,
Yes, sir.
are you going to have any objections to the defense's motion for continuance?
No.
All right. And how long is this trial going to last?
I would say max.
3 days. All right, Ms. Ferguson, Criminal Trial Division, I need a jury trial date, 3 days.
We can do the November 10th.
All right, we're going to be back on November 10th. You say, I remember how that was. No, no, it was me, myself, and I, like the song.
That's it. It's like that regardless of how many people you have.
Oh, it is. All right, your jury trial date is going to be November 10th. Once you sign the reset form, you are excused.
Thank you.
You're welcome. Your clients, who are we starting with?
We'll start with Ms. Castro. Let's start with the oldest case, Ms. Castro.
Desiree Castro. All righty. Thank you for dressing appropriately for court and being on time. And let me see. Odyssey is working a little bit slow. All right, we're set for jury trial today, but as you can tell, it's too late for jury selection. How long do y'all expect this trial to last? 3 days? All right, so if you all could confer with Ms. Ferguson on a jury trial date and then come back here and let me know what it is, just have a seat. They'll bring the reset form to you. Okay. Let me find what page. All right, Antonio Garcia. So on this case, today is your plea deadline date and also jury trial date.
Oh, yes, sir.
So is this going to be an agreement or no?
Judge, I mean, we're both working, seeing if we can work this case out, but we're not there yet.
All right, so then what I will do, Norman, don't set this for jury trial yet. I'll recall this in 2 weeks, and that's the final chance you all will have to reach an agreement. Otherwise, your plea deadline date will expire and the court will not accept any plea bargain agreements with good cause. Otherwise, you have to plea open to the court.
Okay, sir.
All right, Ms. Ferguson. All right, October 28th.
Well, thanks, Judge.
All right, thank you. Thank you for being on time and dressing appropriately. You're welcome.
Yeah, I'm good for.
Oh, thank you. You too. The court is going to call 2025 CR 010790 State versus Nicholas Quinones. Could I have parties announced?
Megan Galley for the state.
Luis Martinez on behalf of Mr. Quinones.
All right, this hearing was scheduled at 9 a.m. It is 3:41 p.m. The defendant did not appear. Deputy Laura, did you make an announcement? Defense, have you had in contact with your client?
I have, Judge. I've been in contact. I do not have any good reason as to why he's not here.
All right, state.
We're requesting a bond forfeiture.
All right, the court will issue a judge's warrant, remand your client without bond. If he makes an appearance, the court will reconsider.
Yes, Your Honor.
All right, thank you.
Thank you.
All right, so we'll be back here tomorrow at 9, but it should be a short docket, which I'm sorry, I jinxed it, didn't I?